Well, I'm going to start. Hello, everybody. My name's Stephen Wood. I'm the director of the Center for Law and the Environment at the Allard School of Law in the University of British Columbia. This is our second no-fly zone talk of 2023 with Canadian lawyer Andrew Gage, who'll be speaking about the Sue Big Oil campaign. The no-fly zone speaker series is intended to bring legal thinkers and actors from around the world to speak virtually about pressing environmental law issues. It aims to foster national and global knowledge exchange without generating travel-related greenhouse gas emissions. It's a bit of a stretch, actually, to call this particular talk a no-fly zone talk, since Andrew is in the room with me here, but he didn't fly here. He took the ferry from Vancouver Island, and so we're going to ask your forgiveness or indulgence in classifying this in the no-fly zone speaker series. We're also joined in the room here at the law school by students in my seminar on green rights and warrior lawyers. I and the law school are uninvited guests on the traditional, ancestral, and unceded territory of the Musqueam Nation and are deeply implicated in the ongoing project of settler colonialism. I invite those of you who are joining in virtually to recognize whose territory you are on and to keep the implications of this fact top of mind as you go about your life and work. And today's talk is being recorded and it will be available on the Center's website. If you have questions and you're joining online, please type them into the Q&A window at any time. Folks who are here in person will be welcome to pose their questions directly. After Andrew's done speaking, we will have a Q&A, and let me just now introduce Andrew. Andrew Gage is a staff lawyer at West Coast Environmental Law, has been a staff lawyer with West Coast Environmental Law for more than 2 decades and is currently the project lead for the organization's climate change program and part of the secretariat for the Sue Big Oil campaign. Under his direction, West Coast's climate work has focused on the legal and professional consequences to industry, government, and professionals of failing to address climate change. Andrew was an expert witness before the parliamentary committees considering the Canadian Net Zero Emissions Accountability Act, which was enacted in 2020, and has published extensively on environmental and climate change law, including academic articles and most recently a book chapter on climate litigation and loss and damage. Andrew dedicates his work to prevent and minimize the impacts of climate change to his 2 children. Later today, Andrew and I will be speaking on a public panel on the Sue Big Oil campaign alongside Vancouver City Councillor Adrian Carr, climate activist Manvi Bala, and West Coast Environmental Law Climate Accountability Strategist Fiona Koza, moderated by the writer, filmmaker, and now UBC professor Avi Lewis. I've been told that in-person attendance at today's event has sold out, but there's still plenty of room to join virtually by visiting climateemergency.ubc.ca. With that, I'm going to hand over to Andrew to give us his remarks. Thanks so much, Andrew.
Thanks for having me for the introduction. This is showing you the video. When you pick that elsewhere.
Yeah, we are still on through the other mic.
Okay, great. So thank you everyone for coming. I'm pleased to be talking to you about the provocatively named Sue Big Oil campaign. This is a campaign that is pressing local governments in BC and I think ultimately all levels of government to bring legal proceedings, a class action lawsuit against global fossil fuel companies for their share of the cost of climate change. Over the next 20 minutes, I'm going to take a bit of a dive into some of the legal principles. I often talk more about the sort of campaign reasons why this is important, but I want to convince you that this isn't just a political campaign claim, but actually a legal recommendation. We need to sue the oil. So I was 19 when the governments of the world came together and signed the United Nations Framework Convention on Climate Change. And in that pivotal document, the world's governments agreed to stabilize greenhouse gas emissions at a level that would prevent dangerous anthropogenic interference with the climate system. I had more hair at the time. But over half of the greenhouse gas emissions in the global atmosphere have occurred after that pivotal date. I've labeled it blah, 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 which I'm using here inspired by Greta, obviously, but using the technical meaning, leaders who pledge action on climate change, but then prioritize short-term profits over real action. As a direct result of that ongoing blah, 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 our communities are increasingly experiencing the impacts of climate change. Scientists found that the 2021 heat dome was 150 times more likely to occur due to climate change than it would have been without. The floods in the fall of 2021, by comparison, were a measly 2 to 4 times more likely. And the 2017 wildfires were 7 to 11 times larger as a result of climate change than they would have been otherwise. So, in other words, we know well above the balance of probabilities that climate change led to 600 deaths from heat in this province and billions of dollars of damage in the regions affected by forest fires and flooding. Similar impacts are being felt throughout the world. Climate change is a violation of legal rights on a massive and unprecedented scale. Some climate scientists believe that civilization itself is at stake. It's a key hypothesis of the Sue Big Oil campaign that there's a direct relationship between the profits of the oil and gas industries and blah, blah, blah. As long as we keep the profits made by the people who generate those products separate from the cost of climate change, we are going to get more blah, 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 and we are not going to be able to solve the climate crisis while these industries, their investors, and governments that support them reap massive profits from the very products that are causing climate change. There's been no social movement that has successfully gone up against deep-seated economic interests without actually challenging the profits of the people making the economic profits. This is a classic externality. One of the long recognized purposes of tort law is to actually ensure that costs are borne by the parties that cause the harm and therefore are most able to alleviate it. So that society as a whole can make more economically balanced decisions. Because we live in an economy that has entirely separated the benefits and the fossil fuel economy from its costs, that doesn't just affect corporate behavior, it affects how this industry is perceived by the public, by investors, by governments, and it explains the behavior of those companies, but also the behavior of governments who continue to subsidize those companies. These companies are not subsidized because they need the subsidies. They are subsidized because they are perceived as wealth creators. But with climate litigation, we have the potential to bring some of those costs together with the benefits and get them recorded on the same balance sheets. That allows us all, but certainly including the companies and their investors, to see that these companies are not wealth creators. They are in fact climate debtors. These costs need to show up at some degree at least to some degree on the balance sheets of these companies so that they and their investors and companies have the incentive to make the decisions that prioritize the health of our planet rather than prioritize blah, blah, blah. We've actually seen more evidence just in the last few days. BP and Shell, two of the oil companies that actually have generally been recognized as being leaders on climate comparatively within their industry, have announced that they will be taking less action in the immediate future because they're just making too much money. It's hard to think of a more stark example of why we need to bring those costs and benefits together and onto the same sheets. This is the Sue Big Oil website. One of the key pieces on it is a declaration which we are asking people to sign. If you've not had an opportunity to sign it, I encourage you to go to www.suebigoil.ca and look at the declaration and sign it if you are supportive. This is the sort of operative part of the declaration, and you'll see that calling on local governments to bring that class action lawsuit to recover a fair share of our climate costs, as well as setting aside some funds towards the cost of doing so, is a key part of the declaration. So given that we are law students and lawyers, and this is a legal audience. We are going to do that deep dive into some of the law. Because of time, I will be oversimplifying and glossing over some things, and we can maybe raise them in the questions in this discussion afterwards. If there's things people think I've missed, and there are. It's a question of how much detail to include. To be clear, West Coast environmental law most likely, and myself, would most likely not be the lawyers bringing this case. I think that's important to make clear up front. We don't expect to benefit from advocating for this case, but we assume that the municipalities and regional districts bringing such a case are going to want to hire the lawyers that have the deepest expertise in class action law and in civil litigation, which is not me. I've done a lot of research on this, and I'm going to share with you my thoughts on what this case might look like. But keep in mind that the council that brings the case may make different choices than I would. Also, I don't want to imply by having in nuisance up here that is the only cause of action. There are now more than 40 court cases brought in the US by local and state governments under a wide range of different legal theories. I think nuisance is one of the most promising, and that's why I've chosen to focus on it, but I don't mean to suggest that there are not other very credible causes of action that could be brought. So, in nuisance. Probably most of my audience are generally familiar with nuisance law. But nuisance is a field of liability that focuses on the interference with the plaintiff's rights in or arising from property. It focuses on the harm rather than very directly on the sort of conduct of the defendant. And really, it's a fairly flexible doctrine that can address a wide range of circumstances. There are two types of nuisance, but I would argue that there's actually in some ways more subtypes of these, but broadly, nuisance is either private nuisance, meaning it's interfering with private property, and in a climate context, that could include displacement of people from their property, the actual elimination through sea level rise of some properties, or it could be more modest but still very significant harm through flooding, heat waves, wildfires, or other climate impacts. Public nuisance is, I think, in some ways a broader category, especially in relation to climate change. It's interference with the public's rights or interests. And I think there are several different levels at which climate change can be said to be a public nuisance. The actual degradation of the atmosphere itself by carbon dioxide can be viewed as a public nuisance, even independent of whether tying that to particular impacts on local public rights. But certainly the increased harm or risk of harm to the general public is a public nuisance, as well as harm to public infrastructure and ecosystems. Private nuisance can also become a public nuisance where enough properties, large enough portion of the public is affected. So there are several different ways in which climate change could be said to be a public nuisance. Now, of course, we haven't yet had a climate nuisance case brought in Canada, but I think it's instructive to look at what the Supreme Court of Canada said in the carbon pricing reference. My citation's cut off on the screen, but the Chief Justice described on the basis of the evidence presented to the court what they found to be the impacts that were already occurring in Canada and were going to occur in Canada due to climate change. And it's a fairly good summary, I think, given it's a paragraph of many of the impacts that Canada is facing. But what I'd like to just point out here is that the impacts described here, I think, almost self-evidently amount to a public nuisance. It's very difficult to read that human-caused actions have resulted in extreme weather events like floods and forest fires, changes in precipitation level, degradation of soil and water resources, increased frequency and severity of heat waves, sea level rise, and the spread of potential life-threatening vector-borne diseases like Lyme disease and West Nile virus, and suggest that that's not a public nuisance. It may also be a private nuisance where you can link, where one of these events can be linked to climate change and affects a specific property or group of properties. Now, it's important to realize that it's actually not contentious as between, there's a perception that there's still some controversy over climate change, but as between the potential plaintiffs and defendants in these types of cases, there's not a lot of controversy. Chevron was asked by a judge in one of the cases in the States to brief the judge on the climate science, and they said, we accept the science. We accept the science as summarized by the Intergovernmental Panel on Climate Change. We accept that fossil fuels are a major cause of this harm. We do not believe that we should be held liable for it, but the basic question of whether a nuisance is occurring due to climate change, I think, is uncontroversial between the parties that are most likely to be present in court. Now, before we dive into the specific parties I'm proposing, I would like to just touch briefly on one key aspect of nuisance law that I think is absolutely critical in this case, and that is that there's a whole series of cases related to multi-pollution nuisance situations. If it were the case that you had to show that one polluter is solely responsible for a pollution situation, a nuisance, it would be very rare that you'd actually be able to get recourse for property owners or for the public faced with nuisance, because pollution situations typically involve multiple polluters. This is not uncommon. And so the courts have addressed that and ruled consistently that if multiple polluters are collectively creating a nuisance, then they may be sued, each of them, for their contribution. The case law seems to suggest, and I've certainly argued that it's the case that if the pollution is detectable, then it is significant. It is not de minimis, it's large enough that they can be sued over it. And your and I, individual emissions, greenhouse gas emissions are not globally detectable. Chevrons, Shells, BPs, Exxons, and other fossil fuel companies are. And it's cut off on the slide, but there is also a basis in the case law for assigning a proportionate responsibility, I think. So why local governments? Well, in short, the short answer is because they're suffering massive amounts of harm, but in a way that is different than individual property owners and is ongoing. Vancouver has been grappling with the reality that it needs to spend approximately $1 billion in the coming decades to deal with rising sea levels. And it's already spending, according to city staff, about $50 million a year dealing with the impacts of climate change or preparing for future impacts. Similarly, Abbotsford, even before its flooding in 2021, knew that they needed to spend hundreds of millions, if not billions of dollars to prepare for floods. These are the direct result of climate change. These are extreme examples, but pretty much every local government faces some amount of considerable amounts of climate change costs, whether it's road maintenance, changes to the stormwater infrastructure, drought management, and the many other ways that climate change affects the residents and municipal infrastructure. In fact, a failure to address those impacts may actually result in the local governments becoming liable themselves when the disaster that is now much more likely occurs. The Insurance Bureau of Canada and the Federation of Canadian Municipalities estimates that local governments in Canada should be spending collectively $5.3 billion every year to prepare for the impacts of climate change. It's a colossal amount. They have very few options to know of where that funding can come from. Local governments own about 60% of public infrastructure. It was all built with certain assumptions about the frequency of floods, the frequency of heat events, the frequency of these different types of events. And those assumptions are out the window. Now, as they build infrastructure, they need to build infrastructure that can withstand a wider range of impacts, because they need to deal with the climate when they start, during the start of the lifespan of the infrastructure, and still be able to withstand the increased extremes by the end of the infrastructure. So even building new infrastructure has become significantly more expensive. Under these circumstances, we feel it would be fiscally irresponsible of a local government to just assume that these costs should be passed on to taxpayers, when there may be those who helped create these problems that should pay some of the costs. So why fossil fuel companies? We have heard over and over again that we are all responsible for climate change. I quite like that. I don't agree with the message, but I quite like that piece. Interestingly, BP, the oil and gas giant BP, was one of the companies that, one of the entities that most popularized that concept of the personal carbon footprint. So, make of that what you will. But if we are all responsible for climate change, and I think that of course we are at some level, then that means that the fossil fuel industry is also responsible for climate change. And right now we have a situation where taxpayers are paying 100% of these costs and the industry is not paying anything. And if the industry is partly to blame, is partly responsible for climate change, they are, I would suggest, more so than most of us as individuals. Their responsibility is really large. One peer-reviewed study by a scientist named Richard Hades suggested, or has calculated that the amount of emissions associated with the operations of products of 90 entities represents about 2/3 of the human-caused greenhouse gases in the atmosphere. Individual companies like Exxon and Saudi Aramco and Chevron are responsible for more than 3% each. And a number of the other large ones are in that ballpark. This research, of course, provides one possible basis for quantifying the respective responsibility of these companies. But to get there, at least my slides are all going to be cut off. To get there, we have to deal with the question of whether you can sue a manufacturer of a product for emissions from their product. Not entirely. I mean, there's a significant amount of emissions that can be linked to the direct operations of these companies. But that 3% figure, et cetera, the larger figures are the operations, but also from the products once diverted. And the leading case in Canada is at first glance not terribly helpful to the Subic Oil case, but it's Hoffman versus Monsanto. It was an unsuccessful effort by organic farmers to bring a class action lawsuit against Monsanto and Bayer for introducing genetically modified canola seed into Saskatchewan. However, the court, when you actually read the decision, it certainly leaves a door wide open for this. The court confirmed that the responsibility for private nuisance is not restricted to the occupiers of adjoining lands, but extend to anyone who actively was involved in causing the nuisance. They did say that courts should be skeptical about using nuisance claims against a manufacturer for the use of its products or invention by another. In fact, they actually said that it would be quite sweeping to find that. However, a nuisance could be brought in principle against a manufacturer where, and this is what's cut off, I gotta remember what it says, it's cut off on my screen too. Essentially where there was a direct causation, that the product was implicated in direct causation of the nuisance, or where there was additional, there was independent malfeasance. In terms of understanding what's meant by direct causation, there are no other cases in Canada that go directly to like manufacturer responsibility, but there are a number of other cases that go to when a business owner who's engaged in a lease or in certain other types of business arrangements can be held liable for the nuisance that their property helps create. And the case, these are just a couple of the cases. They tend to talk about where it's basically, that when you, in this case, lease, but I think for fossil fuel companies sell, that the product will is an inherent part of that product. Or they also use the language around it's intrinsic. It's part of its intrinsic nature. So some of the cases use slightly less onerous language about be readily foreseeable sort of thing. But for the most part, it needs to be really clear when you sell a product that harm will result. It cannot be that the actions of third parties that were not necessarily anticipated have given rise to the nuisance. It needs to be that those additional actions are inextricably tied to the use of the product. Now, of course, for that foreseeability to occur, we have to ask, when did the industry know that their products were actually causing this type of harm? And the answer is quite early. In 1959, the American Petroleum Institute held a conference on the future of energy, and Dr. Edward Teller addressed the attendees, the people at the conference, and said this, basically confirmed that conventional fuel would lead to the greenhouse effect. And certainly over the decades that followed, industry scientists repeatedly issued that warning. And certainly by the 1960s, they knew that their products would cause increased global temperatures, resulting in sea level rise. They had a much more sophisticated understanding of the range of impacts that they were going to cause by the late 70s, early 80s. And they knew even then that those nuisance effects were going to show up in the late 90s, early 2000s. And I'd also like to point out, they're not just selling raw crude, anticipating that it could be used for plastics or something. They are refining, these companies are refining it into forms that can only be used by burning. The concept of independent malfeasance. There is, this is a US case, but it's very instructive, related to lead paint. And the court there found that you could found nuisance on the basis of the companies being sued advertising that lead paint was safe when they knew in fact it was not. And so that of course is instructive because the fossil fuel industry has actively misled the public, funded misinformation campaigns. The American Petroleum Institute, Chevron and Exxon and other parties in the global climate science communications plan had a strategy where they said the victory will be achieved when those advocating for, it's actually the Kyoto Protocol, but on the basis of extant science appear to be out of touch with reality. They didn't just use that information publicly, they also used that misinformation in lobbying government against climate action. The couple articles at the bottom are a column that, or a couple examples of column that Exxon published for multiple years, trying to mislead the public on the climate science, when their very own scientists were telling them otherwise. And in fact, there's a recent study that examines the quality of Exxon's science and finds that it was unparalleled. It was on par with anything going on in the world at the time. They knew. So there are a number of cases that confirm in principle that you can sue fossil fuel companies, none of which have actually been decided on their merits, with the exception of the Netherlands case at the bottom there. That's not a damages case, but it did hold that Shell is responsible for the emissions from its products. So it's highly relevant to this question. So leaving the law to one side for a moment, let's quickly just highlight why this is so important from a broader public point of view. I mean, it is legally possible. I mentioned that this is a photo of the Dutch, the lawyer for the Friends of the Earth Netherlands who sued Shell successfully. Shell is appealing that case, but at the moment, we've got a decision from German courts saying these types of cases can be argued. We've got 40 lawsuits in the US filed by state and local governments. This is a growing movement. Litigation has huge advantages over most of the climate action that we do. First of all, we're not going cap in hand to government saying, please, do something, inviting more blah, blah, blah. We are basically pointing out that we have a right not to have our global atmosphere destroyed, but it also has advantages because it's global in scope. Local governments can sue for harm caused by global companies in BC courts because the harm is caused in BC. The legal test is a little more complicated than that, but that is, that's I think where you can get to fairly easily. But rather than having to go on country by country basis, I mean, Canada's emissions are historically about 2% or 1.8% of global emissions. Chevron's are like 3.2%. So if you can sue one of these companies for the global emissions, you're already having an impact larger than all on emissions, more emissions than Canada emits. It's financially manageable. One of the great things about the Class Proceedings Act in BC is it provides a mechanism for local governments to work together to bring what would otherwise be a very daunting case. And it protects against adverse costs awards. If you were bringing a case under as a class action, you will not generally be responsible for paying the other side's legal fees if you lose. The Sue Big Oil campaign is asking each local government to start by putting $1 per resident into a fund or into reserving it for this purpose. And we think that that is enough to get us to the certification stage of a class action. There is actually, it's popular. We've polled on this, and when people understand that this is a question of the industry paying some of the costs, there are very high levels of public support for this. What's confusing right now is that the public doesn't always understand that we're bringing the lawsuit to recover actual costs. But once that's clear to them, there are very high levels of support for that. When the lawsuit is filed, the certification stage involves the judge ruling up front that there's a cause of action. That's hugely important because at that point, even before then, the company should be notifying their investors that there's a risk of them being sued. But certainly when the judge rules that they could lose, that should be something that they are notifying their shareholders and investors of. The case itself creates incentives for companies to demonstrate that they are acting responsibly, because they'll want to demonstrate that to the court. And it may ultimately encourage transition away from fossil fuels. But certainly if we win, when we win, fossil fuel companies are actually being ordered. That's when we have these costs on the balance sheets. That's when we've successfully brought together the costs and the benefits of the fossil fuel economy. That's huge. It would be a huge result in pressure for better climate agreements. It would be court precedent that can be followed in other jurisdictions. So it's very exciting to think of what we can accomplish with this. So that is the end of my presentation, and I think probably went a little longer than I said I was going to, but we've still got some time for questions.
Now, I am going to, there aren't any questions online. We have plenty of folks in the room to pose questions. So I would invite questions from the audience in the room. Give you a moment. And how about while you're thinking of questions, I could ask Andrew a question. I wonder, can you say anything about the issue of how to obtain personal jurisdiction over global parent companies in a BC court, as opposed to, say, the Canadian subsidiaries, who might not have as many assets?
Yeah. Well, they may not have as many assets. That being said, I think it would be a huge blow to them even if you were successful against the Canadian company. And I guess the first answer there is that the parent, my view is that the parent company and the subsidiary companies are in a joint tort fees or relationship. So they are jointly, although there's some question about whether you can get, I don't think you can get joint and several liability between the different fossil fuel companies, for example. But I think you can between the parent company and the subsidiaries. I think that they are involved in a joint enterprise, the purpose of which is to provide a product that causes a nuisance. So, I think you name both, you sue both, and if they don't show up, I mean that may create challenges in terms of collecting internationally. However, you still have a huge, these companies, subsidiaries in Canada have significant resources, and the prospect of not being able to continue in Canada would be a huge challenge for them. So I think, I mean, at least to argue jurisdiction, the companies in the Ecuador case did show up in, Chevron did show up in, parent company showed up in Canada. So I think there's some reason to hope that they might accept the jurisdiction.
There's a question in the room. I think it should pick you up on the microphone, so go ahead.
Do you believe litigation to be the best way in which to tackle the climate crisis, or perhaps the most effective? So
there's that famous Churchill quote about democracy is the worst of all systems except for all the others. I kind of feel that way about this. I actually think that there's no doubt that the climate change in a rational world that actually dealt with the crisis properly would deal with these issues through global climate negotiations. We would have done years ago. And but the economics of this are all wrong. You have each country being financially rewarded for being laggards, each company being financially rewarded for being laggards. And so you need tools that actually allow you to go after international players from within one jurisdiction. And litigation is almost the only way to do that. Now, it doesn't necessarily need to be just litigation. I mean, you can have legislation that defines the rules for litigation, as was the case in the Tobacco Damages Recovery Act, the BC Act, and the Opioids Damages Recovery Act. And there's certainly tactics and approaches you can use that go beyond, but there is something very powerful about being able to say, there's no political choice here. If you are selling a product, is going to cause global heating, the planet is actually going to warm as a result of your product, you have to pay some of the costs. So I do think that this is probably the most important thing that the local government can do in Canada. In order to have a global effect. Hopefully that answers your question.
Andrew, do you have a sense of what would be the best sort of approach to convince a judge about how to determine the fair share? Let's imagine we get past the other hurdles to the point where it's a question of, the court
apportioning liability.
Yeah, how would I apportion liability?
Yeah, I mean, I think I think I'm not sure I want to prejudge where a judge might go with that. There's been what's a little challenging about it, I guess, is that I think that there are a few different legal theories of liability in play, and that they suggest different answers to that question. Certainly, the first one I was talking about just you're selling a product is going to cause harm. It's the inherent nature of the product. It causes the nuisance. I think what you do is look at the market contribution and say some of this may ultimately they may be jointly liable with in respect of downstream users. However, if those downstream users are de minimis, they're not themselves globally detectable, then the fossil fuel company needs to pay that. They're jointly and severally liable with those downstream users for their products. So there might be some question about where they're selling to like major power companies or something like that, about whether there's some portion that can be apportioned there. But that's what makes sense to me. I could also see a judge just going arbitrarily, well, we're going to say 50% belongs to the manufacturer, 50% to downstream users. But then there's this question of deception. Right, and there's another recent academic paper that actually tries to quantify how much harm was caused by these decades of deception, and that's a different legal theory. As I touched on, it's related, but it seems to me that you can legitimately say that they actually had an impact that goes well beyond what they strictly sold, and so it's going to be. I'm sure there'll be a number of competing theories raised, but. I think at a minimum, we should be talking about what the Richard Beattie paper assigns in terms of liability.
Yeah, and there also might be questions about whether you do all historic contributions or
when they
knew.
Absolutely.
When they knew issue.
When they knew, or someone suggested to me that maybe when we went past the point of it being safe, which is actually coincidentally sometime around, we passed 350 parts per million in the sort of, I believe, early 90s. So similar time to when a lot of these agreements happened, and that's it's an interesting approach.
There's another question about fair shares that arises when you're talking about local governments as plaintiffs. So one objection I've heard is that, well, local governments are not just like ordinary citizens. They made decisions over decades about development patterns that encouraged or exacerbated the problem. So what do you do about that?
I mean, to some degree depends on if I'm right about the whole de minimis thing, that if you're globally detectable, and of course I haven't really answered the question, globally detectable over what time period. But I mean, the large companies are globally detectable on an annual basis. So, but there'd be the question is your municipality actually globally detectable, or is it de minimis, in which case it doesn't matter. But if it is globally detectable, I think that you probably are into a contributory negligence type situation where the judge can take that into account in assigning the relative responsibility. But it's, that's rarely done in nuisance situations, but there is some suggestion in the literature that it can be done. So I suspect that's where the judge, I don't think some of the people on Twitter and like to suggest that this somehow disqualifies you from bringing a claim, and I don't think that's the case at all.
There's a question.
Yeah, hi. So we all assume that when you will win, companies are going to have to pay or take action and everything. But we saw in this class that exactly in exact same case in other states, companies have been technically forced to pay and do things like that. But they had a lot of time find a way to avoid to pay. So do you think it could arrive in Canada? And if yes, what would be the plan? Or do you think that maybe ecocide crime could help if it would be recognized or something like that?
I thought you were going to ask a different question. Okay, so ecocide I think is fascinating, and I actually met Polly Higgins, who came up with the idea, and she spoke at a West Coast Environmental Law sponsored event when she was here. So I think it's very interesting stuff. My challenge with ecocide, so maybe I should say, in case people on the audience don't know, ecocide is the idea that you can criminalize at an international level or possibly domestically the destruction of the environment in its own right, like that's itself a crime. I think it's a wonderful idea in theory. The difficulty I have is the same that I have with sort of the climate negotiations or whatever, that the economics of it are all wrong. I mean, how do you convince global governments that rely on these extractive industries to criminalize the very industries that their bread is buttered on, or how do you convince Canada, if we were to do it domestically, how would you convince the Canadian Parliament to criminalize it unless they kept it very constrained, in which case it's less useful as a shift. It was really limited to a small number of circumstances, maybe there's big public pressure, but it's a big uphill battle to get established new laws that really undercut. I'm not saying it couldn't be done, but I think that it's that's where my questions are. It's like, how do you build a campaign that actually builds the power you would need to get that done? And it would be hard at the Canadian level, and it would be almost impossible globally.
That is the point at which we'll draw the webinar to a close. So I want to thank Andrew very much and thank everybody for joining us. And we'll end with a little round of applause.